Definitely a critical area, one that is certainly fraught with litigation in the world of probate, and that's whether someone even has the capacity to make a will. Now, interesting thing enough, when someone challenges a will, we call it a will contest. And contests are kind of sound like there's competing interests. In a sense, I guess you could say that it is sort of a contest, right? Whether if there's only one will, it's a contest between the will and the laws of intestacy, or if there's multiple wills, then it's a contest to see which will prevail, so to speak. But that's one of the terms that we use here is will contest. So when someone is challenging a will, we call that a will contest. So a couple of things to understand about a will contest is that they must be filed. A will contest must be filed within 120 days after the will is admitted to probate. So if someone wants to challenge the validity of a will or challenge whether that will should be admitted to probate, it must be filed within 120 days after the initial will is admitted to probate. Also, the only parties that have standing to contest the will are the beneficiaries and heirs, and therefore they are considered necessary parties to a will contest and must be given notice. Recall back into your civil procedure course the concept of necessary parties, that essentially if a party is necessary and they are not joined in the suit, then there are issues with that, and the judgments may not be binding on them. So all beneficiaries, and remember beneficiaries, specifically when it comes to wills, we call them devisees, but beneficiaries is a term that essentially encompasses everyone who will benefit from the estate of the decedent. So beneficiaries and heirs are necessary parties, and only these parties have standing. Creditors do not have standing, at least they don't at this phase, even though the probate process as a whole is designed to protect creditors. In terms of the validity of a will, they are not required to be joined as parties. Also about will contests is that the burden of proof is on the contestant. So that's what we call the person who is challenging the validity of the will. That's called the contestant. And the burden of proof is on that person or on that party. And then also to keep in mind that even though there is a will contest, that doesn't necessarily mean that the entire will fail. In California, wills can either fail either entirely or partially. So if there's a specific provision that is contested and the contestant is able to make his or her case, then the will may still stand without that particular term or without that particular disposition or what have you. So that's what we have for will contests. I kind of want to provide a specific context for this. Now, what are the grounds by which will contests can happen? That's what we're going to cover for the rest of our time together here. There are ways, we've already looked at a couple ways, right? Like undue execution, right? So if there is a problem with the execution, that could be grounds for a will contest to challenge whether a particular will should be admitted to probate. So, but what we're going to focus on is the idea of capacity. Now, this is not the first time that you've heard of the concept of capacity, right? You've seen capacity in other areas of law, notably that in crim law, also in contracts, we've seen those. And so the area of wills, trust, and estate is no exception, notably with wills. So in order for someone to have a valid will, they must have capacity. Now, before we get into the specifics, generally that requires very, very little. Essentially, a person only need to be 18 years old, and they need to have some level of capacity. And we'll talk about the mental capacity in specific here in just a moment, but just note that when it comes to mental capacity, or the capacity to make a will, I should say, the capacity is much lower than that of a contract. And so when it comes to capacity, you'll see as you read through this week's cases that In cases where you would otherwise think this person is unable to form a will, you'd be very surprised that the court says that makes a point to say that the capacity to make a testamentary disposition, like a will, is so low that it, in a sense, defies belief. So we're going to be looking at, I hope you look at those cases, but let's take a first look at mental capacity. This is probably the most important aspect of capacity when it comes to will disposition. The other ones we're going to look at are going to be familiar to you already, but mental capacity really is unique. Not that it's a unique thought, but the way that it approaches it and under wills, trusts, and estates is unique. And so essentially there are three elements. This comes from Probate Code 6100.5. And in order for a person to have been deemed to have mental capacity, they must have these three elements. And the first one is that they understand that the nature of what they're doing is testamentary. So understand the nature of the testamentary act. And recall that testamentary means that it is to take effect upon death. So they understand they need to, or the testator needs to understand that what they are doing has this effect of disposing of their property at death. The other thing that a testator must have is to understand and recollect the nature and situation of the individual's property. In other words, they have to know what they have. Okay. Now, please note that it doesn't have to be perfect recollection. Okay, so you don't need to remember anything. I think if that were the standard, none of us would really have capacity. I don't remember every single thing that I have, but they must have a general understanding and recollection of the nature situation of the individual's party. That is a requirement in order to have a testator be adjudged as having a sufficient capacity to make a will. And then finally, the third element is that the testator remember and understand the individual's relations to living descendants, spouse, parents, and those whose interests are affected by the will. Now, the term that is usually used here is the natural objects of his bounty. If it sounds British English, it's because it is. That's where we get that phrase from, the natural objects of his bounty. All that is to say is that they kind of remember and understand their relatives, okay? Who is their spouse? Who are their children? Who are their descendants, parents, etc.? That is required for them to understand. And I like to think of it as that you just have to know and understand their relatives. Of course, you can always use the term natural objects of his bounty. It certainly is much more poetic to understand, and that is the phrase that is commonly used here. But the probate code, that's what I got that off of, makes it a little bit more plain English. And that is to say that they, I think to really bring it down to a point, that the individual has an understanding of who their relatives are. Okay, so really three basic things to have sufficient capacity to make a will. You have to understand that they're essentially making a will. That is to say that what the document they are purporting to execute is a document that will dispose of their property upon death. And then he or she must understand the general nature and situation of the individual's property. Okay, what they have to know what they have. And finally, they have to know who is able to collect. And that is to say, the heirs and beneficiaries. Once again, none of this has to be perfect, but a basic understanding of these is sufficient to say that a person has mental capacity. And as you're reading through the cases, that actually brings up a couple of interesting areas of, is that when it comes to mental capacity, the time that it is evaluated at is at the time that the will or the instrument is executed. Okay, so it is not much later. So if you execute a will 10 years ago, that's when we judge whether or not you have capacity, not whether you have capacity today. So long as a person has capacity at the time that they execute the testamentary instrument, then they are deemed to have a sufficient mental capacity. So The fact that a testator is very old, physically frail or ill, possesses a failing memory, habitual drinker, addicted to drugs, all those things don't necessarily mean that they lack capacity, right? Because what is the basis by which the court is going to determine whether they have capacity? Well, they're going to come back here. They're going to look at these three elements and say, and ask the questions that did the testator understand that he or she was executing will? Did he or she have a general understanding and recollection of what his or her property is? And did he or she know who his or her relatives were? If these three checkboxes are marked, then we have sufficient capacity, even if there is introduction of evidence by a contestant that the testator had these various physical and mental ailments as well. So note that the threshold is quite low when it comes to these things. It's even so low as even if a person has been adjudicated as incompetent, okay, and a conservator or guardian has been appointed to them, that still doesn't mean they lack testamentary capacity. Now, for purposes of contracts, just to provide a means of comparison, under a contract, this person would not have the capacity to contract. Okay, so if you have a conservatorship or a guardianship, the conservatee or the guardian is not judged to have capacity to contract. Not so with freedom of disposition for wills specifically. Even if a person has been adjudged and incompetent, has a guardianship or a conservatorship, that does not necessarily mean that they lack testamentary capacity. So those are going to be some interesting things that you'll see throughout the cases this week as you move through them. And so I wanted to kind of bring that to your attention, to keep that in mind as we move through these things, because as you look at these kind of these various cases, these various facts, and the ones that you'll be coming up against, you'll see that it kind of defies our natural inclination, where we would think, oh, this person has no capacity. The capacity to make a will is very, very low. All right. Now, when it comes to insane delusion goes to mental capacity, but it is a distinct and unique form of incapacity. Now, insane delusion, even though it has kind of this kind of medical psychiatric connotation to it, it is a legal concept, not one of medicine or psychiatry, at least when we talk about it in wills and trusts. So what is insane delusion? Insane delusion is a belief in facts that do not exist and that no rational person would believe existed. All right, I'll say that one more time. An insane delusion is a belief in facts do not exist and that no rational person would believe existed. So if a person is under an insane delusion, that could be the basis for determining that this person did not have sufficient capacity to make a will. But here's the even more interesting fact. Not only must the person be suffering from an insane delusion, there's a causation element. The insane delusion must have caused the testamentary disposition to be set aside. Okay, so there's a causation in a sense, but for the insane delusion, the testator would not have made this disposition. So just because someone has an insane delusion or is suffering from insane delusions still does not mean that they don't have testamentary capacity if that insane delusion did not cause the testamentary, really having trouble with that, testamentary disposition to happen. All right, so insane delusion, not only must one be under an insane delusion, but there has to be a causation aspect of that. You can think about it under the but-for test that you're so familiar with. But for the insane delusion, the testator would not have made this testamentary disposition. Another thing that I want you to think about, so that was mental capacity, and we looked at a specific. Undue influence is not about mental capacity, but in a sense, it is in the capacity category, because the question becomes of whether the testamentary intent required to form a capacity is that of the testator or of someone else. And undue influence is addressed in Probate Code 6104 with a specific definition under Section 86. And undue influence, the rule is that undue influence is excessive persuasion that causes another to act or refrain from acting by overcoming that person's free will and results in iniquity. Okay, so it's one sentence, but really you can break that up into its elements, right? First, you have the excessive persuasion. Then you have the element of causation, causing another to act or refrain from acting. Then you have the overcoming of a person's free will. And then finally, you have a result in iniquity. When you have those all together, then you have undue influence. And when you have undue influence, the court may set aside either the disposition, or if the undue influence was such that it resulted in tainting the entire will, then the entire will may be not admitted to probate. So a very powerful defense if you find yourself on the end of having to defend, or not to defend, to challenge a will for a client. Undue influence is certainly a tool in the tool bag to challenge the validity of that will. If the facts support a showing of excessive persuasion that causes another to act or refrain from acting by overcoming that person's free will and resulting in iniquity, you may have a case for undue influence. Now, whether someone is deemed to have been undue influenced, the court will consider certain factors. And I listed them here for you. The court will look at the victim's vulnerability. So it was the victim in a position where they would be vulnerable. Were they receiving care? Were they bedridden? Were they locked away? Those kind of things. What was the victim's circumstances? And if the circumstances were such that the victim was vulnerable, the court will consider that in determining whether there has been undue influence. Also, the relationship between the influencer and the victim as well. Okay, so the influencer's apparent authority. When it comes to undue influence, the court will also look at that. Not only how vulnerable is the victim, but what about the position of the one who's doing the influencing? Are they in a position where they can essentially take advantage of the victim's vulnerability? And then I'll look at the actions, specific actions and tactics of the influencer to also see if there was one of undue influence. So the various actions they can do, whether they're secreting away the testator, hiding them, not being able to contact other people, and what other actions they may have engaged in, that will also come into play in terms of what the court considers to determine if there is undue influence. And then finally, the equity of the result. And so, what is the result? If the result is that that the natural objects of his bounty, right, that his relatives are essentially disinherited, that could also play a factor. Now, that's not dispositive. Once again, these are factors, but the court will look at this in its totality to determine whether there is undue influence to either set aside that particular clause or term in the will, or set aside the entire will in its entirety and deny the admission to probate. So those are the things that I like you to focus on when you look at undue influence. Keep this in the back of your mind as you move through this week's material. Now, when it comes to undue influence and fraud, which we'll get to in just a moment, there are certain presumptions that the law will look. These are called statutory presumptions of fraud or undue influence. And so if it falls into one of these camps, essentially the presumption is that these were procured by fraud or undue influence. And we kind of looked at that already when we looked at the witnessing requirements for the execution of an attested will, right? That the presumption arises that if one of the witnesses is an interested party, that they procured it by fraud, undue influence, menace, and what have you. And so similar to that, if there's a donated transfer to one of these four persons, there's also a presumption of fraud or undue influence. And those presumptions arise in these situations. If there's a donated transfer to the person who drafted the instrument, and not just the person, but his or her relatives and certain associates, then there is a presumption that it was procured by fraud or undue influence. Now, you'll see this theme that even though usually the person specifically who is engaging in one of these acts that will take under this will that was procured by fraud or undue influence, it really doesn't just cover them. It covers a gift under the will to a relative or a certain associate, right? It doesn't have to be the person who's actually engaging in the act. If it's someone who's relatively close to them, then they may also, a presumption of fraud or undue influence may arise in those situations as well. So first one is the person who drafted the instrument. Second one is if the person is a fiduciary. If the fiduciary is also in receipt of a donative transfer under a will, then there's also a presumption that it was done so under fraud or undue influence. These last two are big ones. Care custodians, we see this a lot in elderly care facilities, unfortunately. And of course, we talked about elder abuse very, very, very briefly towards the beginning of the semester. But in these cases, that if the care custodian of a dependent transferor, that is the person who makes the will, gets this gift, and they're a care custodian, there's a presumption of fraud or undue influence. That the idea here is that these persons should not be receiving under the instrument because the idea here is that they essentially procured it by means of taking advantage of their position of trust. So the person who drafted the instrument, a fiduciary, a care custodian, and also a care custodian who commences a marriage, cohabitation, or domestic partnership with a dependent transferor within 90 days after services were last provided. So if you someone gets a gift, and they get this gift within 90 days after services were last provided, okay? Not when they actually get it, but when the will is made. If it is made within that time, there is a presumption that it was done so because of fraud or undue influence. Now, what's the difference between 3 and 4? The difference between 3 and 4 is that 4 addresses an area where there is no presumption of fraud or undue influence, and that is if you are married. So if there is a disposition to a spouse, there is no presumption of fraud or undue influence in those cases. But here, what they're trying to essentially close the loophole where a care custodian says, okay, don't worry about it. I won't be the care custodian anymore. What we'll do is we'll get married. And so the presumption will not apply. Well, Congress or the legislature closed that, and there is now a presumption of fraud or undue influence for a care custodian if they enter into a marriage or domestic partnership or cohabitation within 90 days after their services were last provided. All right, these last couple ones, very quickly, are ones that you've seen before. So these are not specific to just wills and trusts, but certainly are areas that you want to consider if you come across a issue on an exam where you are dealing with capacity. And one is fraud. Right, so fraud is actionable under the probate code, and fraud happens when a testator was willfully deceived as to the character or content of an instrument, or with respect to the facts material to disposition. Right, so we have fraud in the factum, right, which is the first part. Testator was willfully deceived as to the character or content of the instrument, or fraud in the inducement, which is with respect to the facts material to disposition. All that you've covered in other courses, so I won't belabor them here, but just know that there is a cause of action for fraud that challenges the capacity of a testator to a will. All right, and then there always has to be causation. So just having fraud is not enough. There has to be a requirement of causation. That is that the testator must actually act in reliance on that fraud. So not only must there have been fraud, either fraud in the inducement or fraud in the factum, but there also must be causation. That fraud must have caused the testator to act in a certain way. If you have those, then you may have a case for fraud. And the remedy is if fraud taints the whole will, then the will is denied probate. If only certain provisions, then those provisions only are there. And I should also point out that one of the remedies, if you cover this in remedies, great. If you haven't got there, you'll see this when you get to remedies, is the concept of a constructive trust. And constructive trusts are generally put there when the denial of probate is adequate, right? So what if there is fraud and we just deny the will to probate? What they may do is continue to move forward in the case and instead impose a constructive trust on the person as a way of denying the benefits to that person, but still keeping up with the application of the law there. So I'll leave constructive trust. We don't get into that too deep in this course. Just know that that is a remedy that is available if there is a finding of fraud in terms of procuring the will or procuring a device under a will. And then tortious interference with is another one. And tortious interference, like I said, you've seen this in torts already, so I'm just going to briefly go over it. And a tortious interference is an action that is not brought by the estate, but by the aggrieved heirs or beneficiaries, and generally against a third party for interfering with an expected inheritance. So very similar to the tort concept, it is available here as a cause of action under a will contest. And the requirements, very briefly, are that there is a reasonable expectation of receiving some interest from the decedent. There is causation, right? That the interference caused a change in the disposition. The defendant had knowledge of the plaintiff's expectancy and deliberately interfered with that. The interference was wrongful, tortious in its own right, and directed at someone other than the plaintiff, and the interference damaged the plaintiff. So very similar to that, the elements in a tortious interference, with a slight variation there in terms of making it fit for will contest, but very similar in that sense. So if there is a tortious interference, then that may be a claim. The key note here is that this is generally one of last resort. The courts generally don't like to go here when it comes in terms of causes of action. So really a tortious interference is only available if there's no other adequate remedy in probate. Similar to what we saw in fraud with a constructive trust, tortious interference, they really don't like to go here unless there is essentially no other adequate remedy in probate. So keep that in mind as we move through. And then the final one is one of mistake. Now, there's a couple of mistakes that can be had here, but the one I want you to focus on this week as you move through the material is one as to the contents of the will. Certainly, you can categorize those into two categories. The first one is an ambiguous will. An unambiguous will. So if you have an unambiguous will, then if there is a mistake, it may be reformed if there is clear and convincing evidence that establishes that the will contains a mistake in the testator's expression, and also established the testator's actual specific intent at the time the will was drafted. All that to say is that if it's an unambiguous will, then there could be reformation, which is a remedy for mistake, that essentially we can fix the will if there's clear and convincing evidence, but we can't look at extrinsic evidence. We can only look at the will itself. So even if there is a mistake in the testator's expression, we have to say that it is established inside the will. Okay, so we don't allow extrinsic evidence in these cases. The will itself has to contain the mistake in the testator's expression and also establish the testator's actual specific intent. Okay, so for instance, let's say paragraph 1 makes a disposition to in a certain way, and then let's say 50% to my daughter, and then the next line says 5%. And then the next line says 50%. So clearly that 5% is the mistake there. It's supposed to be 50, not 5. We can only look at the will itself. So other portions of the will are unambiguous, and they point to the fact that there's a mistake. In those cases, mistake as to the contents, there can be an action to reform the will so that the testator's actual intent at the time that he or she drafted the will is carried forward. Now, if you have the case of an ambiguous will, then Evidence still may be admissible. We can allow extrinsic evidence, but only to establish or clarify the ambiguity. Okay, so in a sense, we're not really mistaken in that sense. Really, what we have is we have an ambiguity, and we're trying to clarify what is meant by the ambiguity, and so we allow extrinsic evidence in those cases to clarify that. In a sense, not really a mistake. It is covered here under a mistake, but really, I see that more of one of clarifying an ambiguity in a term or a disposition rather than one of mistake.